Welcome, everyone, to the Africa Arbitration Day, New York. This is part of the 2023 CPR Global Conference series of events. We're so glad you could be with us here today in person and online. And I want to give special thanks for the organization of this program to the Africa Arbitration Day New York Steering Committee. Special thanks to the person who had this beautiful idea and brought it to life with CPR, Naui Ukabula, and to the other steering committee members, Tiwalade Adoroju, Prince Alex Iwu, Chinwe Ohanali, and Mohammad El Murtadi Suleiman. So these members of the steering committee have worked tirelessly to bring this beautiful program to life. It is the first of its kind here in New York with the CPR Institute, and we're so pleased to be able to present that. By introduction, my name is Kanar Nahikian. I'm the Director of International Initiatives for the CPR Institute. So I also want to thank our speakers. As you know, we have two panels to present to you today, and now we will be telling you a little bit more about that. But in the meantime, I also want to give my thanks to the speakers for organizing such substantive programs for you today. I also want to thank our sponsors for the global conference. We had a diamond sponsor, which was Debevoise and Plimpton, and two gold sponsors, Curtis and also White & Case. We also want to thank our 2023 Global ADR Champion sponsors. These are the sponsors who support CPR Institute through our annual meeting, which takes place every year. And by their support, then it extends to support of various programs throughout the year, including this one. These types of programs would not be possible without their support. So I really am grateful to them. I also want to thank our hosts here today who are also co-hosting this event with us, the New York City Bar Association. For those of you who are members of the City Bar, you come here often as I do. I'm pleased to be wearing two hats today. I'm also a City Bar member and I serve as secretary for the ADR committee of the City Bar. So it's thrilling to me to bring two of my favorite organizations together today to present this program. So thank you to them for hosting us today. So as I mentioned, I'm with the CPR Institute. The real name of CPR is the International Institute for Conflict Prevention and Resolution. So it's a long term, but it's important sometimes to actually understand that. I know some of you are coming us today who are not currently CPR members. So I do want to just take a minute to explain a little bit about our organization to you. So we were established in 1977. So we've been around for a little while. It's a nonprofit independent organization, and we have sort of two arms of the organization. On the one side, we have the CPR Institute, which is made up of our membership, and it puts on programs like this quite often. We have members from around the world. They join us in various capacities, including our international advisory boards, who I have the pleasure of working with. We have advisory boards in Europe, Canada, and Brazil. But as I say, we have members throughout the world, and we are always welcoming of program ideas, just like this one, that will appeal to those members' interests and practice areas. We also have a young professionals group, and I want to mention that because today's program also was supported by our young professionals group called YADR. So this is the Young Leaders in Alternative Dispute Resolution. It's important to mention this because this is the next generation of our practice, right? They come up with ideas like this, just as I said that Naui did. He serves on our YADR steering committee. He came to me with this idea and we said, sounds great, let's run with it. And so YADR is constantly coming up with cutting edge programming just like this. If you yourself are interested or you know of junior colleagues who might be, applications open every year in the spring. So please look for that around May. We should have applications open for you to consider applying to join the steering committee. As I said, there's a second arm of CPR. So we have also the dispute resolution services side. This is a boutique ADR provider. with case administrators and a panel of distinguished neutrals. So we have these two separate arms, and yet we work together to bring programming like this. So I invite you to please take a look to see how you can perhaps engage with us again in the future for future programming, and perhaps even joining us as a member. I also want to invite you to consider joining us in 2024. We'll be holding our annual meeting in March. So the dates are March 6th through 8th, 3 days. We will be in Philadelphia for our annual meeting, and that will be 3 days full of programming, networking, and all kinds of events taking place in Philadelphia that week. So consider putting that on your calendar and joining us in Philadelphia. So I know we want to get to the good part, and I think it will be important to hear a little bit more about this program and what to expect. And so for that, I'd like to introduce the person who brought this program to us. Nawi, if you would please say a few words. Thank you so much, everyone. And I look forward to connecting with you all at some point today. Thank you.
Thank you so much, Kanar, for that very warm introduction and for getting us kicked off. And so hello, everybody. Thank you so much for being here. My name is Nawi Ukabula. I'm an associate at Debevoise and Plimpton in the International Disputes Group here in New York. And I'm so grateful to everybody for being here. I'd like to just start by giving all of you a round of applause for showing up today. And to all of those online too, we couldn't be more delighted to have you tuned in. Just so everybody knows, we have some snacks and beverages outside. If you weren't able to grab anything before we get started, you'll be able to in between sessions. And as Kanar said, I'm going to tell you a little bit about Africa Arbitration Day New York, why I think we need it, and why I hope you're all as excited about it as I am. So throughout my career, I've always tried to stay engaged on issues related to Africa arbitration, or arbitration with an Africa connection. That's always been an area of interest for me. And throughout my career, I've encountered countless of really brilliant people that share that interest. Many of them based in Africa, where there's an incredibly rich and vibrant community with regular programming, and a lot of them based in Europe, where there's also lots of programming. But a lot of them based here in North America, and even right here in New York. But, you know, although it's something I've really looked for ever since I've been in law school, I was never really able to find regular programming here in North America, or any kind of standing forum for like-minded people that are interested in arbitration with an Africa connection. Sure, there's, you know, the one-off panel, but nothing that's kind of really regularized. And so after I joined CPR, it was something that I was already thinking about, because it was something that, you know, that had been on my mind. So something I was thinking about potentially being able to bring to CPR's programming. And so I joined as Kanar mentioned, the YADR committee, and met Kanar last year, when she was still, I think, a new director of international programs, and super energetic. And we chatted, and one of the things we talked about is how, you know, I really felt like there was an underserved community and an opportunity to bring programming that would be really well received. And Kanar was, you know, super supportive from the very, very beginning, and has been absolutely instrumental in every kind of step of the way, from getting the institutional support of CPR to handling last-minute logistical details that allow all of us to be here right now and to be comfortable. So huge thank you to Kanar. And I'm also super grateful to each of the members of the steering committee, who are kind of those like-minded individuals I've met over the years that share this interest. It's also been an absolute delight to work with them on the programming that we're going to deliver today. So now let me tell you why I believe we need Africa Arbitration Day in New York. I think the first reason is because Africa-related arbitration issues are pertinent to North America African arbitration. And we're seeing a growth in arbitrations involving African parties generally. For example, the LCI caseloads, including sub-Saharan African parties, grew from 4.5% in 2011 to 11.7% in 2020. And growth in North American African arbitration generally means also that there's going to be more of a need to focus on the really important issues that are kind of coming up in developments in African arbitration. So there's also going to be more arbitration because of the growth in the economic growth in Africa generally, right? So according to Deloitte, the value of construction and infrastructure projects in Africa grew almost $300 billion from 2013 to 2021. International renewable energy project finance deals rose by 28% to $11 billion in 2020. McKinsey estimates that by 2030, Africa could unlock $3 trillion in consumer spending, and that revenues of African companies could grow by $550 billion. And so this economic growth will hopefully bring increased prosperity in Africa. But unfortunately, as we all know, it's also going to come along with more disputes. And so in the meantime, we're seeing a very dynamic and an evolving arbitration landscape in Africa. Africa arbitration has grown by leaps and bounds in recent years due to new pro-arbitration legislation in Africa, more arbitration conferences in Africa, more training for judges and arbitrators, the advent of technology and remote procedures. African arbitration institutions continue to grow in number. There's now over 90, and they are getting stronger and stronger in reputation and garnering more attention. And so as the number of North American African arbitrations grow, these developments become even more pertinent, and it's important for us to have a forum to talk about them. The second reason I think we need Africa Arbitration Day is to create a forum for community building among practitioners interested in Africa-related arbitration that's accessible to those of us here in North America. We all know the importance of community. It gives us an opportunity to find that next mentor, colleague, counsel, arbitrator. And it also gives us an opportunity to seek solutions to some of the challenges that are facing arbitration in Africa. I mean, obviously, we've had tremendous progress, but there are still very real challenges on the horizon. These include a huge opportunity gap for African arbitration institutions and practitioners who are playing catch up with other jurisdictions in US, Europe, Asia, and elsewhere. Capacity building is needed to strengthen legal and institutional infrastructure. African arbitration institutions suffer from inadequate international exposure and perceptions of corruption, interference, and bias. So addressing these challenges is really important to me because I'm very passionate about economic growth in Africa. And I truly, genuinely believe that arbitration can provide an alternative that can circumvent some of the disincentive to foreign investment that comes along with some of the gaps in judicial capacity that we have on the continent. So by creating a forum for community building, I really hope we can come together to learn from each other, share insights, and try to promote the brightest possible future for arbitration in Africa. So now let me tell you a bit more about the program that we've put together today to try to serve those purposes. As many of you know, the program started this morning with an arbitration moot for students interested in Africa-related arbitration. And I really have to take my hat off to fellow steering committee member Prince Alex, who has been the driving force behind the arbitration moot. The students used a modified version of the CPR mediation problem, and they submitted both written and oral arguments, and were absolutely fantastic. We'll be giving out the prize for best oralist in between the two panels. And I'd like to just, thank each of our arbitrators. Thank you so much, Bethel and Mahaliana. Thank you to the coaches that agreed to work to prepare the students for the moot. And thank you so much to the students for being here. I understand that Juan traveled all the way from Colombia to be here today. And that's absolutely just so admirable that you were able to do that and still perform, at the top of your game. You definitely have a future in this profession. So we also have two panels featuring some, the moot, the idea of the moot is to hopefully build capacity and build up the future leaders of arbitration related to Africa. We have two panels that feature some of the most distinguished current leaders of arbitration in Africa and related to Africa. So we'll have the first panel, which will explore some of the most exciting recent substantive developments with Africa-related arbitration, including the Africa Arbitration Academy's Model BIT and the Africa Continental FTA. They'll discuss the FTA's innovative investment protocol, which contains a commitment to negotiate a dispute resolution mechanism with arbitration. And they'll explore what that mechanism could look like. And then panel two will look at the institutional landscape for arbitration in Africa. Among other things, panel two will discuss some of the most promising African arbitration institutions, the key considerations for choosing between ad hoc and institutional arbitration, and exciting developments, including the new arbitration acts in Tanzania, Nigeria, and Sierra Leone that have been adopted in the last 3 years. And that panel will also look at some of the challenges facing those institutions and hopefully present some kind of bold, outside of the box creative ideas for addressing them. And then after the second panel, I really hope that you will all join us for a networking reception with hors d'oeuvres and cocktails sponsored by my employer, Debevoise and Plimpton. I do have to ask your forgiveness for one omission. The reception really should include a spread with koshery and injera and beef tibs and fried plantain and bubuti and Nigerian jollof. Oh. Actually, no, what would be even better is a sample of jollof from different West African countries so that we can have a survey and definitively establish once and for all that Nigerian jollof is the best. We were not able to pull that off this year, so we're gonna just have to kind of imagine we're having that feast like the Robin Williams Peter Pan movie. All jokes aside, we're gonna have a lovely reception. Thanks to Debevoise, the hors d'oeuvres will be delicious and the booze will be free. So I would be remiss by stepping down without kind of echoing the thank yous that Kanar gave. And I think, first of all, thank you to Kanar and CPR. Thank you to our co-host of this event, the New York City Bar Association, in particular, the African Affairs Committee and the arbitration committees. Very special thanks has to go to Martha Harris and Linda Kemble. Huge thanks to the Africa Arbitration Day New York steering committee, which has been fantastic. Very big thanks to each of the speakers, some of whom have traveled great lengths, and in Ronke's case, internationally, to be here with us today. So thank you to them from the bottom of our hearts, and all of our sponsoring organizations and financial sponsors, which you can see on this poster to my right. So let's get underway with the first panel, the state of arbitration in Africa and the prospects for Africanization. Allow me to turn it over to my fellow steering committee member, Mohanad, who will be serving as the moderator for that panel and will introduce you to our panelists. Thank you all.
Thank you, Nawi. Let me also begin by thanking the New York City Bar Association and the Center for Conflict Prevention and Resolution for hosting us today in this unprecedented and hopefully very special event. I would also like to echo the thanks to my steering committee members, Nawi Ukabiela, Prince Alex Iwu, Tiwa Dijoro, Chinio Hanil, and of course, Kanar Nahikian, whose work and dedication has made today possible. Now, as Nawi explained, the first panel will talk about arbitration in Africa and the prospects for Africanization, and it will focus specifically on the investment protocol of the agreement establishing the African Continental Free Trade Area and the model BIT of the Africa Arbitration Academy. And I think before we begin the discussion, it will be useful to provide some background so that we have some context for the discussion. In May 2019, the agreement establishing the African Continental Free Trade Area entered into force. The agreement's main objective is to promote trade in Africa by creating a single market for goods and enhancing the African states' economy. And in February of this year, African states adopted the agreement's protocol on investment during the 36th African Union Summit in Addis Ababa, Ethiopia. The protocol calls for adopting an annex dedicated to rules and procedures for dispute management and resolution between investors and state parties to the protocol within 12 months of the protocol's adoption. And at the same time, in July of last year, the Africa Arbitration Academy issued a model BIT that African states can adopt as their standard BIT. Now, the Free Trade Agreement, its investment protocol, and the model BIT deal with different subjects, but they share some common features that are aimed at promoting investment and trade in Africa without compromising African states' ability to implement necessary national policies and achieve their sustainable development goals. In addition to that, both of them contain provisions that are designed to ensure that they will benefit local African communities and promote Africa's contribution to dispute resolution by limiting a perceived imbalance in African states' contribution in such mechanisms. Now, these features are not new. In 2015, an instrument prepared under the auspices of the African Union and called the Pan-African Investment Code already reflected many of those features in an effort to reform international investment law within Africa. Some have referred to such efforts as the Africanization of international investment law. Now, the investment protocol and the model BIT come against a background of hundreds of BITs, regional economic and trade agreements, and different domestic laws dealing with foreign investment that are already enforced in many African states. As of today, African states have signed 975 BITs. 211 of those are intra-Africa, meaning they're between African states. In addition, since the signing of the Lagos Plan of Action in 1980 and the Abuja Treaty in 1991, many regional economic communities have emerged in Africa. Those communities aim to foster regional integration among their members under the wider African economic community, which the Abuja Treaty has sought to establish. Now, some of those communities even adopted investment protocols and model agreements that African states members to those communities can adopt as their investment agreements. And at the local level, many African states have recently also reformed their laws and regulations regarding investment. Recent examples include South Africa and Tanzania, both of which have enacted reforms to their foreign investment regimes. Africa's competing investment regimes raise the question of how can the investment protocol and the model BIT be implemented in a way that does not conflict with the regime governing foreign investment that is already in place in many African states. More importantly, because of the BIT and the investment protocols and innovative provisions, they both could guide efforts to attract foreign direct investment to Africa and play a significant role in shaping the future of that investment. And as a result of that, they deserve a careful analysis, which is what this panel will try to do. Now, I have to admit that analyzing all of the issues that arise from the investment protocol and the model BIT is not an easy task, given the number and the complexity of the issues that they present. However, the good news is that today this is not going to be a problem, because today we have an incredible panel that combines between academia and practice, and that will be more than able to cover at least as much as we can of those issues in the time that we have. Today's panel includes Jennifer Glasser, who is a partner at Whiting Case. She is a member of Whiting Case's International Arbitration Group. She represents corporate and sovereign clients across the globe in international arbitrations and dispute resolution. She is an experienced oral advocate who has secured victories valued in excess of $1 billion in commercial and investment treaty arbitrations. She has also helped her clients settle complex international disputes amicably through negotiation and mediation, and has advised clients on U.S. court proceedings related to arbitration, clause drafting, and foreign investment political risk mitigation. Jennifer is active in dispute resolution across Africa, including assisting an East African state with mediation capacity building, representing the owner of a power plant in Nigeria in a New York law-governed construction arbitration under the AAA commercial rules, and advising on issues of sovereign immunity and arbitral award enforcement risks in connection with a renewable energy project in South Africa. Jennifer is the co-editor of the CPR Corporate Counsel Manual for Cross-Border Dispute Resolution. She currently chairs CPR's Arbitration Committee and serves on CPR's Advisory Council, with previous mandates on CPR's Cybersecurity Task Force and Task Force on Virtual Hearings. She also recently served on a task force of the International Council for Commercial Arbitration that published guidelines on standards of practice in international arbitration. Today's panel, we also have Professor Uche Iwolokwa-Ofudil, who is a senior fellow of the Musawwar Rahmani Center for Business and Government at Harvard's Kennedy School of Government. And she's also the E.J. Ball Professor of Law at the University of Arkansas School of Law. Professor Ofudil's teaching, research, and scholarship focus on international dispute settlement, intellectual property law, food law, international investment, and business law. And she has authored numerous book chapters, articles, and essays on different aspects of arbitration law, and is the fellow of the Institute of the Chartered Mediators and Conciliators in Nigeria, and a regular speaker at the annual meetings of the African Arbitration Association. She currently serves on the editorial advisory committee of the International Legal Materials and was previously a book review editor for the Law and Practice of International Courts and Tribunals. She has taught and lectured at many universities and academic institutions around the world. She is a member of the American Law Institute and Council on Foreign Relations, and she has led leadership positions. She has held leadership positions on numerous organizations, including the African Society of International Law as Secretary General, the ABA Section of International Law as co-chair of the Corporate Social Responsibility Committee and vice chair of the International Intellectual Property Rights Committee, at the Nigerian Bar Association Women Forum as the deputy head of research and documentation, and at the American Society of International Law as co-chair of the Africa Interest Group and Intellectual Property Law Interest Group. Professor Ofudil obtained her law degree from the University of Nigeria and her LLM and SJD from Harvard Law School, and she also has a certificate of training in arbitration from the World Intellectual Property Organization in Geneva. We also have Professor Ebironki Odumosu Ayono, who is a professor at the University of Saskatchewan, Ontario. Dr. Odemoso Ayono earned her PhD from the University of British Columbia, Canada, and she was also appointed as Acting Associate Dean for Research and Graduate Studies at the College of Law, and she is a barrister and solicitor of the Supreme Court of Nigeria. Dr. Odemoso Ayono is a member of the editorial boards of several journals, including the Business and Human Rights Journal, the African Journal of International Economic Law, and the Journal of African Law, and she is also a member of the editorial committee of the African Yearbook of International Law and the co-chair of the Midwest Interest Group of the American Society of International Law. Professor Odemoso Ayono has received several competitive research grants, including grants from the Social Science and Humanities Research Council in Canada, and she has presented her research at several workshops, conferences, and forums. Her research has been published in several leading journals and books. And finally, we have Alice Gyamfi, who is an associate at DLA Piper. She focuses her practice on international commercial investment arbitration. She has represented sovereigns, individuals, and multinational companies in arbitrations under leading institutional ad hoc rules. And she has particular expertise in the mining and life science sectors. Her scholarly work is focused on how legal instruments like the ISDS mechanism can be leveraged in international trade, particularly by African states and regional economic communities, to rebalance asymmetrical rights and obligations within the existing international arbitration regime. Alice also has a keen interest in helping African states to build capacity within their judicial systems, and she currently represents the South Sudan Ministry of Justice and is working alongside the cabinet to establish a hybrid court to adjudicate the very first commission on truth, reconciliation, and healing in the nation's history. Alice earned her JD from Penn State Law with concentrations in arbitration and international comparative law, and she completed her LLM at Columbia Law School, where she was a Sulzberg-Cutler Global Fellow. So with that, I think we can start the discussion, and I think it is appropriate to start where I ended in my introductory remarks, which is the question of how can the investment protocol and the model BIT be implemented in a way that does not conflict with the regime that's already existing in many African states, given the number of the BITs, the number of regional agreements, and also sometimes conflicting domestic laws governing foreign investment that are already in force in many African states. Professor Uchi, I'll take the lead on that.
Thank you. As you write, thank you for the just making. Okay, good morning, and thank you all for being here. You did a good job of just presenting the landscape. So when you're thinking about fragmentation in African investment regime, you definitely have to think about the continental level, as you rightly said, that we have an investment protocol. And then at the sub-regional level, we have quite a number of agreements. And then you get to the bilateral investment level, and there are many treaties that are in force now that have conflicting provisions. And even you get lower to the foreign investment law at the national level. And in the last 10 years, quite a good number of countries have passed laws that sometimes conflict with their bilateral investment treaties. And of course, we can't forget investment contracts, that even when governments have the treaties, there are also contracts that could also conflict. So what is the situation? How do you harmonize? I think there are several options which definitely the investment protocol needs to address. One, there could be the option of just terminating most of the existing treaties, right? Terminate most of the existing treaties. And this can be done in a harmonious way. You know, when the treaties expire, the government should not renew them because with more treaties coming into force, you're going to have more problem. Second is to deal it through amendments, right? The idea of creatively amending all the treaties with a view to harmonization. And then third will be joint interpretation. The idea that you can jointly interpret the pre-existing treaties. So you say no need to, and not every treaty can be interpreted in a very innovative way, but to the extent that is possible, the idea of joint interpretation needs to be considered. Fourth is the idea of just having a moratorium, right? Moratorium on new treaties, so that for a while, You just said there should be no new treaties. Government should just pause until we have that harmonization in place. And then fifth would be maybe thinking about a common African investment framework, right? Beyond the investment protocol, perhaps thinking about transferring competence. And that this is very controversial, transferring competence on investment treaty to the AU, so that going forward, these treaties can only be concluded at the AU level, representing all African states. These are not very radical, right? In the investment protocol, Article 49 of the investment protocol actually attempts to deal with this, right? Article 49 of the investment protocol says a number of things, and I'll just read it out. It's supposed to be on the slide, but it's not moving. It was my fault. Okay, so it was my fault. So here is, as you can see, quite a number of provisions that we're thinking about. And the next is you have a number of areas to deal with in terms of harmonization. And as I said, thinking about it through joint interpretation, amendments, and stuff. So this is Article 49, and the article, is it Article? Sorry, I can't even see what it's saying. Well, Article 49 of the Article 49 says something, and I'm going to get to that in a minute. I hope that is it, right? It says, is that it? No.
Yeah, that's it. Yeah.
Thank you. I can't see. Yeah. I'm so blind. So this is Article 49. It says existing BITs concluded between state parties shall be terminated within 5 years from the entry into force of this protocol. So it's trying to think of termination of all existing BITs. And it says upon termination of existing BITs concluded between the state parties, their survival clauses shall also be terminated. So it's complete termination, including the survival clauses. Then the second, it says state parties shall not conclude new BITs among themselves, right? So moratorium on new BITs. And then it says state parties shall make best efforts to review and revise relevant existing regional investment agreements. And then finally, it says state parties may take into account the requirement of this protocol when negotiating international investment agreements and when reviewing existing international investment agreements concluded with third parties. I think that there's an attempt in the investment protocol to deal with harmonization. Does it go far enough? I don't think so, right? There's still a lot of gaps. And the gaps are in the second part. When it talks about termination, I think that that's a good thing. We have so many BITs, and most of these BITs are old generation BITs. And even if you think about amending them, the amendment process is not always very easy. And then the second part, it says members shall not conclude new BITs among themselves. But what about the BITs with third states? What about BITs with non-European countries, with emerging economies? It doesn't quite deal with that. And then it says members, when you come to the regional level, members shall make best effort. So at the end of the day, even with Article 49 in place, we're still going to have a complex, fragmented framework. And I don't think it went far enough. It should have really addressed a number of issues. It should have addressed the issue of amendments and termination and joint interpretation. The question, of course, is the capacity. You know, the capacity to deal with amendments and the capacity to deal with treaty interpretation. So far, African governments have not really stepped in terms of interpreting the treaties. And the question is why? Why are they not engaging in joint interpretation? Why are they not engaging in, these are some of the questions we can address at the end, but that's my own thought in terms of harmonization. And it's not going to be very easy. Thank you.
Well, it's not going to be easy based on, as you said, the huge number of agreements that are already in force. But now moving on, Professor Ochi, to a different subject, which is a subject that has been covered a lot recently in a lot of discussion and sometimes even criticized, which is the question of ISDS, Now, the investment protocol itself does not provide for ISDS, but it also provides that settlement of investment disputes are to be governed by an annex that will be dedicated to that, and that annex is now in the process of being finalized. However, initial drafts of that annex do provide for ISDS, and similarly, the model BIT also provides for ISDS either through exit or arbitration under the UNCITRAL rules or arbitration before one of Africa's arbitral institutions. And the question that I have for you now is, given the criticisms of ISDS as a system, do you think that its inclusion in the annex to the investment protocol and the model BIT is good for Africa?
That's also a great question. Is the ISDS good for Africa? I've thought about that for quite some time. And in Africa, it seems that you have 2 or 3 groups, right? They're the group that think that ISDS, they're really against ISDS. And we see that in some countries, right? So South Africa is definitely a country that has come out and said, no more, no more, okay? Beyond South Africa, we actually have some regional treaties that also make no provision for ISDS. A good example is the SADC Finance and Investment Protocol. It makes no provision. And then the EAC model BIT says that the preferred option is not to have the ISDS. So you have that group, but you have a group of states that have never really criticized ISDS. And you could say are pro-ISDS, because even in their domestic law, they make provision for ISDS. And then you have the third group of states that have what you might say conditional ISDS, where there's, like the ECOWAS Supplementary Treaty and the COMESA Common and Investment Agreement. It makes provision for ISDS, but it limits access to ISDS through exhaustion of domestic remedy. So you could say that in Africa, there's really no consensus, despite all the criticisms of ISDS. There's no consensus across the board to abolish ISDS. And there are a number of reasons for that, right? One, of course, as in the introduction, we talked about there's growth in Africa, economic growth. And with economic growth, there's always that issue of attracting and keeping foreign investment, right? And that is something that is very dominant in the minds of African policymakers. It's easy enough to say no ISDS, but how does that translate? And what is the impact on foreign investment? A second issue is that it looks to me that some African countries are not really too happy or wanting to cede their historical contribution to international investment. Because if you look at the history of international investment and arbitration, African countries have played a big role. Another issue is that we are having a lot of African investors too now. And I think that across the board, you find that when countries begin to export capital, they start thinking about the protection of their own investors. So while in the past, Africans just received, and it was easy to think about just protecting the domestic policy space, as African countries are sending out investors, the question of protection, whether it's South African investor in Nigeria, Nigerian investor in other countries, we're seeing that intra-Africa movement. And if the protocol encourages and this idea of regional integration goes for, we're going to see more cross-movement of capital. So what do you do? I think that the protocol and the model BIT tries to strike a middle ground. What is that middle ground? The middle ground is that they provide for ISDS, but then they try to introduce some African sentiments into it. Whether they go far enough is a different question. So right now, what I see in the investment protocol and in the model BIT is an attempt to be in the middle. And the question, of course, for me would be, would that middle ground attract a country like South Africa? What will be South Africa's position? Because South Africa in its domestic law has already shown ISDS. That is the biggest question now. So in the investment protocol, it really doesn't say much, but several things jump out. One, dispute prevention. And that kind of really goes back into the Africa deals a lot with dispute prevention. Even at our own domestic village level, dispute prevention is very strong in African dispute settlement mechanism. dispute resolution, I mean, alternative dispute resolution, it also encourages that significantly, which again is very African-centric, right? And then on the issue of just dispute resolution, it says the annex is not ready. But if you look at the 2021 zero draft, there are a number of things so if the things in the zero draft are adopted, this is what it will look like. So dispute prevention, ADR, mediation, those are all emphasized. When it comes to choice of arbitration forum, it says under any arbitral rules adopted by African institutions or dispute resolution center. So it allows for other arbitration forum, but it gives room and encourages use of African arbitration centers. And I think 20 years ago, one could have laughed at this. But now we see so many strong arbitration centers in Africa. There's a serious commitment towards strengthening arbitration frameworks in Africa. And then seat of arbitration, it says, unless the disputing parties otherwise agree, hearings and meetings shall be held in the territory of a state party. Okay, that's another nod towards encouraging arbitration in Africa. There's a statute of limitation that counterclaims. It also goes on to provide for when it comes to establishment and composition of the tribunal. One interesting phrase there, it says that the presiding arbitrator shall be a national of an African state other than the state party to the dispute or the state party of which the investor is a national. Another significant thing there is the issue of non-disputing party, where it allows for non-state actors to kind of participate. And then the last thing is appeals. And so what you see here is an attempt to strike a balance, be within the encourage ISDS, embrace ISDS, but modify it to take into account current criticisms of ISDS. When you look at the model BIT, it goes even a little bit more. The model BIT talks about the overriding treaty principle. The overriding treaty principle in the model BIT talks about Ubuntu. Ubuntu, that idea of having the community involved, interpreting the treaty with the community in mind. It talks about dispute resolution, mediation, and the model BIT kind of it's kind of very similar in many ways. So what exactly is it? I think that personally, I think that is a good middle ground, given the fact that African countries are now exporting capital, and I think it's projected to grow, given the fact that Africa remains concerned about attracting foreign investment. If you look at the last report from UNCTAD, Africa is, as a region, even though foreign direct investment is growing, as a region, Africa is at the bottom. It does not compare to countries in Asia or Latin America. So there's that concern, right? Whether the perception of Africa as a poor investment climate I think is wrong perception, but there's that concern. And given the fact that the lack of consensus, I think that is a good middle ground. And I think that there could be some improvements to it. There are a number of things that I think is wanting in the framework. And if there's time, I will address that later. Thank you.
Thank you very much, Professor Uche. So one of the things that you touch on in answering my question is this idea of striking a balance or introducing some African sentiment, you said, into the dispute settlement mechanisms. And the question or the issue that I would like to raise now is, how did the investment protocol and the model BIT deal with the goal of promoting African states' contribution to dispute settlement mechanisms, protecting the special needs of some of Africa's local communities, and also helping African states achieve their sustainable development goals? And this question is raised specifically in light of previous attempts to create a uniform investment code, specifically the Pan-African Investment Code, which already reflected these goals in some of its provisions. And the question that I have for Jennifer is, how did the model BIT and the investment protocol deal with these matters?
Thank you. And thank you for having me here today. I am honored to be on this all-women panel. I would also note and involved in a dialogue with this audience on Africa and New York arbitration. Let me start by saying I fully agree with Naoi's sentiments that there is a direct business imperative for this conference and for the initiatives that we see reflected in the investment protocol and in the model BIT that you've already heard a little bit about today. It is not simply academic. I was with the general counsel of a major hotel group last week in Costa Rica. And oftentimes when I talk to general counsels, they're not familiar with investment treaty arbitration. And I get very excited when I meet someone who knows what I do and who's interested in hearing about it. And he was telling me that one of his key agenda items is pressing Tanzania, where they currently have a small but growing high-end luxury safari operation. And that he told me, I didn't investigate it before the panel, he said there was no treaty in force between the United Kingdom in that case and Tanzania, and we're educating him on potential other ways to structure around that. But the bottom line is, it is front of mind of folks who are currently operating in countries in Africa and who are looking to expand. And foreign business wants to have an investment treaty mechanism in place as a protection to facilitate investment growth. So with that, let me walk you through the procedural framework that is in place in the two documents we're focused on today, the model BIT and the investment protocol, and introduce you to how they balance these competing considerations of attracting investment while also ensuring an Africa-driven dispute resolution mechanism. Now, I'll start with the draft investment protocol, and we heard a little bit about that today. I think a key point on the draft investment protocol, and that's not the slide on the screen, is, I don't know, is there a way to go back?
Yeah, the red one is the one you go back. Yeah.
There we go. So the draft investment protocol does not yet establish an arbitration procedure. It actually doesn't have an investor state arbitration mechanism. There was an earlier version of that protocol from November 2021 that did have investment arbitration provisions. Those came out of the latest version of the protocol that was drafted and issued in January of this year. That document simply says that within 12 months of the protocol coming into force, another annex will be adopted and negotiated that will address dispute resolution. So as of now, the investment protocol only has a general reference to seeking to amicably resolve disputes through mediation, negotiation, etc. And the question of arbitration has been deferred entirely. So what we're seeing there is this debate that has already come up, right? The conflicting positions of different countries across Africa and different constituencies, with some constituencies being pro-arbitration and others being very anti-investor state arbitration. And so the compromise position in the latest version of the protocol is simply to punt the issue down the road. With that, I will focus on the procedural protections in the model BIT and provisions in the procedure that are designed to ensure an Africa-led process. So first, turning to the, I also have terrible eyes, I can't see that screen, I'll have to look here. On the screen, we see the clause from the model BIT on the place of arbitration, which has already been introduced. The concept here is that the, other than ICSID, where under ICSID arbitration, by default, the place of arbitration is Washington, D.C. The legal place of arbitration shall be a city of a state party of the African Union other than the investor's home state and the host state. So the approach here to ensure a homegrown process is to quite literally seat the arbitration within the region. How does that compare to some of the previous efforts underway in the investment treaty arbitration space in Africa? the Pan-Africa Investment Code doesn't directly address seat of arbitration at all. So it doesn't have any clause like the one you see on the screen that establishes a potential seat of arbitration. It does say, and I apologize not to have a slide on this, but I'll read it to you. It says that where recourse is made to arbitration under paragraph 3, the arbitration may be conducted at any established African public or African private ADR center, and that arbitration shall be governed by the UNCITRAL rules. Now, there's some ambiguity in that language. Is it a choice of location of the arbitration hearing? Is that language may be conducted at seat of arbitration language meant to convey the legal place of arbitration? Or is it simply meant to set out the institutional administrative framework that will govern the arbitration? So that clause left open a lot of questions and suffered from some ambiguity that risked delaying the arbitral process at initiation. Now, it's probably best read as not meaning the legal seat of arbitration, but either referring to the administrative framework, right, or a place where hearings shall be held. And in the absence of any seat of arbitration, the issue, as in any case, will be decided by the arbitral tribunal in accordance with the applicable arbitral rules and consulting the parties. Now, comparing the two regimes, the benefit of the one we see on the screen in the model bit is localizing the proceedings and the seat in Africa contributes to a homegrown process, protects against at least the perception of a foreign-led process. But from the perspective of foreign investment, it may give rise to concerns insofar as African states have less developed arbitration jurisprudence. We heard about new investment-friendly arbitration investment-friendly laws coming out in Tanzania. Several states have been revising their arbitration laws, but these are newer efforts that are underway. And that may lead to concern about having an arbitration seated in Africa and a concern about a risk of an unfriendly or unsophisticated judiciary that risks interference in the arbitral process. Now, to quickly go over a couple of the other procedural protections in the model bit on arbitrator selection. We've already heard briefly about this. The model bit says that the parties are to select their arbitrators, and then the co-arbitrators are to select a chair, taking into account that it should select a chair that is of African descent. Now, there is a carve-out to that, which we'll come to a bit later in the presentation. The last clause that I wanted to highlight, and we heard, again, we touched on this a little bit today, is the framework for allowing participation of non-parties. And that really falls into two categories under the model bit. Either a non-party to the dispute that is a state, right, that is a member of the treaty framework can make a submission to the tribunal. And then separately, there is a right of local communities, NGOs, other interested parties to make amicus submissions. That is a framework that permits inclusivity, that will allow for local considerations on the ground, local communities, voices of indigenous people to be heard as part of the arbitral process. And this is another mechanism that ensures a sufficiently African process and is broadly consistent with the international framework. With that, I will, there's a lot more in the 80-page document, but I said.
Thank you. Thank you, Jennifer. Thank you. I'll give the floor to Alice, see if she wants to add anything on this topic. Same question.
You can take the slides down.
Just to add that Jennifer has given a really excellent kind of overview of the process. The provisions that stand out to me are the ones where African states are essentially saying that they're prioritizing investment relationships that have more depth rather than just breadth, right? And so to me, Article 1, right, redefining investor and investment and what those definitions are. So Article 1 now says that a qualified investment can only be one that an investor can make if that investor has substantial relationships or is making a substantial investment in the host state. So it's now no longer enough to make an investment, even if profitable, and enjoy the protections of, the dispute settlement regime. The next one, Article 29 and Article 30, to me stand out because they really have to do more with how we are operationalizing these investments, how we are facilitating them in a really practical way. So Article 29 relates to the development of human capital, and the purpose of that is to build capacity. And I think the portion of that provision that's really important is that it emphasizes middle management and managerial positions when you are building capacity in your workforce. So Congo right now is at the fore politically in their cobalt industry, right? If we're looking at Article 29, how that would play out in a real sense is you cannot simply hire, let's say, 5,000 individuals who are mining in the cobalt industry. You must also hire 200 middle management, right, who are really responsible for the production stream. And then an additional, let's say, 50 individuals who are responsible for liaising with corporate. So you're supposed to be making an investment in every aspect of the value and the production chain. And I think that's critical because in a lot of, I'll speak for the mining, sector that I'm particularly involved in, we see the greatest amount of investment at the very bottom, right? Hiring the individuals who are doing the mining. And this is really a push to hire at all rungs of the production stream. And the next one, Article 30, is about the transfer of technology and making a really meaningful investment there. And not just the transfer of technology, but the transfer of know-how, the transfer of information that relates to the expertise in that sector. Because if we need to maintain these construction projects, if we need to maintain, a mining concession agreement for 100 years, it cannot be the case that we have to import that talent all the time. If we begin to develop a steady stream and a strong stream of talent that is at all levels, maintenance can then begin to happen on an Africa level and not require an investment of capital all the time.
Thank you very much, Alice. So, Dr. Ronke, we've just listened to Jennifer and Alice talk about all these different aspects of the modern BIT and the investment protocol, which deal with allowing African states to make more significant contributions to dispute settlement, protect their local communities, and also achieve their sustainable development goals. And the question that I have for you is whether you think these kinds of provisions, these kinds of protections are needed or even justified.
Thank you for that question, and thanks to everyone who has joined us today and to the organizers. Your question really directs attention to an issue that has been at the heart of what is being called Africanization, right? The issue of sustainable development, as well as the protection and interest of local communities. We know that Africa, as has been mentioned here this afternoon already, requires foreign investment, right? Development. But at the same time, Africa is one continent where there's been a lot of significant impact on the local communities as a result of foreign investment. So that balance is required in Africa, and it's quite apposite that Africa is leading the changes in light of its experience. And as been mentioned, I do quite agree that Africa is taking the middle ground in seeking to attract foreign investment and protecting its peoples. So to kind of reflect a bit on local communities, to reflect on sustainable development. I was sharing some thoughts in a recent article of mine about international investment law, ISDS, and the types of issues that we're talking about today. And I want to explain why I say that Africa is taking a middle ground, even though it appears that it's going further than many traditional investment treaties have done in the past. So first, investment law has proceeded really as a system that, and it seems very easy to say this, but it has significant implications. It has proceeded as an investor-state system, a system that only really focuses on the investor and the state. We talk about ISDS, it's investor-state dispute settlement. And that's in spite of the fact that it has significant widespread impacts on local communities, especially those ones that are the host and affected communities who directly encounter the impacts of investment activities. So, but many of these disputes really, even though we call them investor-state disputes, are not only really investor-state disputes. Many of them are way more complex. And I think that that's partly what some of the instruments that we've been looking at today, the investment protocol, the model BIT, was Jennifer that mentioned the Pan-African Investment Code. All of these instruments are beginning to reflect some of these. In fact, the investment protocol talks about trying to achieve a balance between the state, the investor, and the local communities as part of its objectives. But this is not to say that some disputes are not clearly investor-state disputes, but many are not correctly categorized because they're way more complex. And those are some of the things that these instruments are beginning to turn their attention to, and that lawyers, I believe, really need to begin to turn their attention to as well. In the African context. The second, which I believe that some of these instruments have begun to challenge, is that almost singular focus on investment protection. And I must preface these remarks with the observation that it is not to suggest that investment protection is not necessary or absolutely necessary. The challenge is trying to measure every other legitimate interest against investment protection. Right. And I think that that is that balance that some of these instruments are getting into by beginning to start to talk about investment protection on the one hand and investor obligation on the other hand. So to the extent that the investment protocol, for example, has started to help us to rethink some of these things, to an extent, they do reflect on the structure of ISDS. They do have an impact on the rationale of investment law, but they don't completely abandon those foundational bases for this area. That might be pleasing to some. That might not be pleasing to other people, but there's that out there. So we see this ambivalence going on. So if one turns, for example, to the investment protocol with regards to first local communities, it does, for example, say that investors are required to respect the rights of indigenous peoples and local communities, respect free, prior, and informed consent. But then this latest version of the instrument has this caveat that was not in the older one that says, but that is subject to the whole state's position in recognizing indigenous peoples in the first instance, local communities. And we know that many African countries reject the idea that any groups within the countries are indigenous peoples. So you start to wonder what teeth those types of provisions have, given that they've now been subjected to the domestic law of the host states. There are provisions around assessment of like circumstances when you look at national treatment or most favored nation treatments, asking that they take into account the effects of the investment on local communities. There are provisions that refer to environmental impact assessments, social impact assessments, all of these trying to mitigate some of the challenges in this area without abandoning the system. But then if we turn to sustainable development. That's one area that the protocol also focuses on significantly. It does say, for example, that states have the right to regulate. We know that there have been many traditional ISDS cases that have tried to negotiate and navigate that issue of states' rights to regulate. The provisions around climate change policies, labor and consumer protection, measures for pursuing development goals that are very important in the African context. For example, local content measures, right, that international law struggled with, but African states are now very clearly saying we want them as part of the system. So there is that kind of ambivalence, like that middle ground, not rejecting the system as illegitimate, as some has argued, but at the same time, including measures to try to strike a middle ground. The extent to which these will go, we would see. So, for example, there's language like investors shall, but then sometimes there's language like investors shall endeavor. So not so binding. So we'll really see how it goes when all of this comes into force. An effort, but how far it goes, we'll see.
We'll see. Thank you. Thank you, Dr. Ronke. Jennifer, do you share Dr. Ronke's views that these kinds of provisions are justified or needed in Africa?
I fully share the view that there needs to be mechanisms in order to reflect the local circumstances, in order to engage local communities. We've all seen examples of a dispute resolution process that is foreign dominated. It has little likelihood of success. It jeopardizes the legitimacy of the process and thus its effectiveness as a mechanism to attract foreign direct investment. So in the substantive protections, I fully think it's needed. I did want to drill down a little bit, if you'll humor me, on the balance question, right? Because there's competing objectives, right? Ensuring a sufficiently Africa driven process that achieves Africa's sustainable development goals and also attracting foreign direct investment. And so there's the question there is, are the provisions designed in order to ensure an optimal dispute resolution solution in terms of issues like efficiency, costs, and quality of results? Because those are factors, the legal framework that investors are going to be looking at in terms of assessing their risk and assessing the sufficiency of the process as a risk mitigation mechanism. So to go back to the two areas that I outlined to start with, arbitrator selection. We have the provision that the arbitrators, the co-arbitrators will select a chair of African nationality, a nationality not of one of the contracting parties. Now, that is a good provision insofar as it will ensure and drive, one hopes, growth of a body of African homegrown talent to arbitrate these disputes. That's very much an imperative that is needed as part of this process. We looked at some statistics in preparing for the panel, and we found that in a survey of 31 new arbitrations registered at ICSID in 2022, only 2 African arbitrators were appointed on those 31 new cases registered in 2022. It's a very small volume that is currently being appointed to cases. We need to grow the pool of talent, and we need to, of course, get that talent seated on tribunals. So provisions that have a nationality requirement will help to further that objective. But there is always a concern when we give general clause drafting advice, whether it's in the investment treaty landscape or the commercial landscape, of not including too many specific criteria for arbitrators that will limit your pool of available candidates and potentially prevent you from having the right arbitrator that may have the right industry experience for your dispute, or that has sufficient investment treaty experience in order to deliver an award that is consistent with the treaty and consistent with public international law. So there is a need to balance these competing issues of capacity building on the one hand and an arbitrator selection process that allows for a wide enough pool and takes into account where we are in terms of growing that talent pool in Africa. Taking a step back, I think that the model bit does a pretty good job of balancing those two, because it provides, on the one hand, that the co-arbitrators will select someone who is of African nationality. So that imperative is built into the mechanism. But it then goes on to say that where it is not possible to do so, that another qualified candidate will be appointed. So it does at least open the door to the appointment of a president who is not of African nationality if there is a need in a particular case, although the standard is quite high, right? The standard is it is not possible to nominate someone of African nationality. So it has to be literally impossible to find someone in order to open that door. And then the last point I would add is the model bit, and I think also the investment protocol, have mechanisms that go to this capacity building issue. So the hope is that both the selection requirements coupled with capacity building mechanisms in these treaties, capacity building efforts that are already underway to grow our African talent pool, will mean that this provision strikes the right balance between getting qualified arbitrators who also have relevant industry expertise or otherwise, and ensuring an efficient dispute resolution process. Very briefly, I won't say much on it. The amicus provision that I outlined earlier, that one is largely identical to the existing framework in international law for non-party intervention. It mirrors the non-party intervention procedures under the ICSID Convention and the ICSID arbitration rules that were updated in 2022, I believe. So I think that really strikes the right balance and will ensure that there is a voice to local communities. Because as one of my co-panelists said, these are disputes between investors and states, but it's not just that. There are so many competing considerations and constituencies that have a stake in the game. And this will enable those constituencies to express a voice in these proceedings and hopefully to further their legitimacy.
Thank you, Jennifer. You know, in your answer, you referred to a survey and you gave some numbers about African states' contributions in cases. And I would also like to share some numbers that I came across as I was preparing for this panel, and I found to be very interesting. Now, despite what some of us might think that African states did not have much contributions under the exit jurisprudence, they have actually taken the initiative under many of those developments. And I found this to be interesting in an article written by Dr. Emilia Onyema, where she identified a number of instances where African states were the first to take initiative. One is that the first state to sign the Exit Convention was actually Tunisia, which is an African state. And also the first state to ratify the Exit Convention was an African state, it was Nigeria. And the first exit arbitration was against an African state, it was against Morocco, 1972, Holiday versus Morocco. And the first exit conciliation case also involved an African state. It involved Madagascar, 1982, Seritex versus Madagascar. And the first exit case in which the claimant was a state, as opposed to the claimant being the investor, also involved an African state. It was the Republic of Gabon versus Société Cyrite. And the first exit award was also in a case involving an African state. It was Adriano Gardella versus Côte d'Ivoire, 1977. And finally, the first exit annulment request was in a case involving an African state. It was Kloschner versus Cameroon, 1982. Now, despite that, if you look at the caseload of exit and you see the number of cases that have been brought against sub-Saharan countries and you compare that with the number of appointments that were made by those states, you will see a huge gap. In a report done by Exit about all the cases that have been registered before Exit, between the first registered case, which was in 1972, until June of this year, what they found is that sub-Saharan countries have been involved in 14% of all of those cases, yet their share of all the appointments of arbitrators, conciliators, and ad hoc committee members is only 2%. And when you compare that with Western European countries, they have been involved in only 8% of all of those cases, yet their appointments of arbitrators, conciliators, and ad hoc committee members, is 46%. Almost half of those appointments were done by Western European countries, which just goes to all of your points that such provisions that call for a more significant contribution by African states and dispute settlement mechanisms is needed and is justified. Now I want to move on to another topic, which I think all of you discussed briefly or referred to as you're answering my other questions, which is the question of how did the model BIT and the investment protocol deal with the investors' protections as opposed to the investors' obligations towards the host state, as opposed to the host state's obligation to the investors, and also how did they deal with the protections, at least the traditional scope of such protections that are given by the host state to the investors. Alice?
I mean, I think the name of the game from this panel today is you're hearing balance. Balance the competing factors, balance the interests, balance the equities to the extent you can. And when it comes to the investors' duties and obligations, I think that's no different. The model BIT and the protocol are both interested in finding a more equitable balance of obligation. So ensuring that we create a system where the duty of the host state to protect these investments from discriminatory treatment and unlawful expropriation is leveled, or at least has, is on equal footing with the obligation to respect what are really fundamental and internationally recognized, human rights, protecting the environment whilst you are operationalizing your investment, ensuring that you are engaging in just ethical business principles, and doing that in a way where it's earnest, right? And not just as an afterthought. I know we're running on time. So to the second portion of your question regarding the scope, I want to highlight the FET provision, right? Because we know that in the protocol, we don't have an FET provision as we know it traditionally. We have narrowed the scope of the FET provision in favor of the administrative and judicial treatment provision in Article 17. But I think the mind behind that is not necessarily to narrow the scope and to offer less protections, but to be more clear about exactly what kind of investment we are protecting and what kind of behavior we are protecting it from. The main criticism of FET provisions is that they don't really clearly identify the scope of protections. And in the absence of that clarity, you have a growing body of case law where tribunals are interpreting these FET provisions in a broader and broader way, right? The Waste Management v. Mexico case is an excellent example of that. And I must have quoted it a dozen times in different pleadings, right? The tribunal found that the minimum standard for FET is not met where the treatment is unfair, unjust, idiosyncratic, discriminatory, infringes on a situational, sectoral, causes, racial prejudice. I mean, it's all manner of interpretations, and it's very, very broad. Now, that could be precisely what the parties intended, but because there was no clarity in the FET provision, that's what you get. So I think you do have a narrowing of the investors' obligations, but I think it's in favor of adding more clarity and thus more predictability when, as Jennifer said, you're advising a party and they just want to know the metrics. They want to know, based on these simple facts, right? What can you tell me if you can give me kind of a gut reaction? And if you offer a little bit more clarity, I think you can offer predictability. And that's exactly what African states are trying to do.
Thank you, Alice. Dr. Ronke, do you think that these kinds of provisions that require the investor to perform certain obligations towards the host state or narrow some of the traditional scope of some of the traditional protections that are given by the host state, do you think that these are compatible with the goal of promoting direct investment in Africa?
Thank you. That's a tough question, because some would say that investment treaties probably don't really play much role in terms of investment decision making, like where an investment will go. The jury's out on that, but some make that argument. So that investors really start to care sometimes when things go awry. But as to where they might invest, they might consider a host of other issues. So some would make that argument on the one hand. But on the other hand, there's also the position that there's a lot of talk about this area now. Investors are very aware and they care about the treaties, they care about the protections, they care about the provisions, right? But to kind of take it from where Alice left off, one of the things that is important with what the investment protocol at least tries to do is that clarity. What exactly are we measuring, right? So, for example, compensation, they talk specifically, the protocol refers specifically to fair and adequate compensation. When it comes to the national treatment and most favored nation treatment provisions, there is an outline of factors that will be assessed in determining life circumstances. Or, for example, when it comes to administrative and judicial treatment, it says very clearly, do not interpret this to be equivalent to fair and equitable treatment, but that it includes the minimum standard of treatment under customary international law. It's something that has been debated for a long time, right? So they come out and are very clear, at least to an extent, as to what exactly is covered. So it might not be a case of dialing back on investment protection. It might be more a case of clarity. But one thing that is sure, though, is the inclusion of investor obligations and obligations for investments. The investment protocol wouldn't be the first instrument to include that. African countries have been kind of dipping their toes into that water for quite a bit. The Pan-African Investment Code does some of that. The ECOWAS, the Economic Community of West African States, does some of that as well. The often cited Morocco-Nigeria bilateral investment treaty that, by the way, is still not in force. I think 6 or 7 years after it was adopted, does some of that as well. And then when one turns to other areas of international law, business and human rights, right, there is a lot of debates out there, at least since the UNGPs, or even before the UNGPs, as to investor responsibility. Some prefer to talk about investor obligations. But what these instruments do is to specifically go into the issue of investment obligations. And I don't think that there is a lot of going back on that. That's the reality. Because, for example, when one starts to look at some of Canada's investment treaties as well, you see some of that. So it's not just in Africa. It looks like that's the direction in which most of these treaties are going to be going. And if that's where most treaties are going anyway, there isn't a case of a race to the bottom. There isn't a case of a race to the top. That's just going to be the new standard. And it wouldn't really have an impact. Like if all states go in that direction. And for this is a Pan-African instrument. If all African states are here, there isn't much of a choice to be made as to, oh, will I invest because of that, or will I not invest because of that?
Thank you, Dr. Ronke. Unfortunately, we're running out of time, but I would love to hear.
One follow-up point.
Yeah, just a quick follow-up.
So I take issue with the notion that it's just about clarity in terms of the definition of FET in the two instruments we're looking at. And let's just focus on the model bit in particular. It certainly does clarify in much more detail than earlier generations of treaties what fair and equitable treatment means. So it does go to achieving clarity, but it then has an enumerated list of certain specific classes of measures that are a treaty violation. And it's not an exemplary list of these are the types of measures. It has a narrow list of enumerated measures, and only those measures are a violation of FET. And they're very focused on procedural protections. They write out a class of treaty protection that has been increasingly recognized over the past 5 to 10 years, and goes back much longer than that, which is investor protection of investor expectations. And then in a newer generation of case law, a protection against a fundamental change in the legal framework that deprives an investor of value. And so I think we do need to ask a question of whether that narrowing of protections is consistent with the Sustainable Development Goals here, and is consistent in particular with growing renewable energy projects, because the substantive protections that I just mentioned against fundamental changes in the law have led to a significant wave of cases in Europe brought by renewable energy investors as a result of changes in the legal regime, in incentives regulation over the past 10 to 20 years in Europe. And so the narrowing of FET in these instruments that we're looking at will have a tangible impact on investors and the relief that they may be able to recover, in particular in sustainable development and in the renewable energy space, which I expect to have a lot of activity in the coming decade.
Thank you, Jennifer. Professor Uchi, you want to add some brief final comments?
Yeah, brief final comments, 5 points. One is this notion of Africanization. I'm not sure if I like it or not, because with Africanization, it gets people thinking that it's something different, unique, and against the established order. And I'm not sure that is so. And so I think when we use that, we want to be very careful about that term. Because in many ways, when you actually go through the documents, they fall short on some levels. Second is the issue of model BIT that we've talked about. African countries have a tendency to adopt model BITs, but very frequently those model BITs do not ever get implemented. And so it's important to keep an eye to make sure, because is there really Africanization if it ends at the level of model BIT? With that, you talk about the Nigerian Morocco BIT. Everybody talks about that. And as you rightly said, it's never been implemented. But one thing that is curious to me, the Nigerian Morocco BIT is very wonderful. But then you look at the Morocco-Japan BIT that was concluded after the Nigerian Morocco. It has less of the features in the Nigerian Morocco BIT, which begs the question. When African countries are negotiating with each other, they bring out all the Africanization hat. But when they are now concluding BITs with third countries, they tend to be timid, very, very timid. And that is something that needs closer consideration, because most of the futures that we see here, they don't make it into. And this is very important, because African countries within themselves have about 50 BITs that are actually enforced. But with third countries, there are some 500 old generation BITs that are still enforced, that are really not up to standard. So when we're talking about Africans getting involved in arbitration and being nominated, it's not reflected in some 500 BITs that are enforced with third countries. So those are some of the things. And that last but not the least, on the issue of investor obligation, these documents are very good on investor obligation. But when you look closely, they're not really binding. The languages are so weak as to be almost useless. They're not binding, and they're not even up to the standard that you see in some other countries, right? So we know that in Europe now, you mentioned the UN Guiding Principles. Many of the UN Guiding Principle talks about remedy, the right to remedy. None of these documents provide remedy for the communities. And the last thing is that we know that in the EU now, they have the corporate sustainability due diligence. There are all these due diligence regimes coming up. The EU also has the corporate sustainability reporting directives. Those are all at the highest level. And I think that I just want to push before we end. When we think about Africanization, I think it's important to think about it both in terms of intra-Africa relationship, but even more important, in the relationship between Africans and third countries, mostly developed countries. Because until we get to that level, can we really talk about Africanization? Thank you.
I don't think so, unfortunately. All right.
Not 5. Just 1 point, not 5 points. I really like those points because when I first started to speak, I said that I just completed some work and I was measuring some things, including the investment protocol against that, and they do not measure up to those standards. But that's something on one side. But the thing I wanted to kind of leave us with from my own perspective is this. And it's one of the points that Uche was making here. And it's a positive for me to say it at the end so that I can say it and just get away from here. It's that a lot of these things, that issue of the Morocco-Nigeria BIT, and then Nigeria goes ahead or Morocco goes ahead to do something completely different. For example, I'm doing some research on African countries, along with a few colleagues, African countries' investment treaties with Canada. They all look like the Canada template, not like any of the African countries' templates. And you can give so many more examples. There's one question, there's one word out there, and no one gets to ask about it because I'm leaving. It's called power.
Thank you, Dr. Ronki.
Thank you so much to the panelists and to Mohamed, who was an excellent moderator, for really just doing an exceptional job of bringing out some of the most pressing and intriguing issues, and really drilling through them in a way that was incredibly comprehensive, given how short of a time period we had to cover them.